I luckily ran across one of the greatest books I've ever read. I'd rank it next to Adam Smith. It's called History of English Law from the Time of Edward II, and by Pollock and Maitland, whose first names I don't know. It is a phenomenal book, and you probably have never read it, but I have read it twice. I'm reading it again, because every time I read it, I see more things in there, because it's the story of the development of the law of England, which is our law, but it's also the study of the development of our customs and our behavior and our rights and our political system. It's a phenomenal book. I'm really, set aside this interview, I'm telling you, look at it. It's just great. And so I got very intrigued by this, the structure of property rights we're developing, because he contrasts with the French and the Roman law, which did not develop in England, and why it didn't. So I thought, gee, I'm going to look some more at this. I started working on this property rights stuff and writing up what I thought I understood, and it was fun. That's how it started. Those little conversations, that little event. If you look at economics as a study of how markets work, and in markets you trade rights back and forth rather than goods, and that makes a big difference to emphasize you're trading rights to goods rather than goods. You'll think that's a very important distinction, but it's a crucial distinction for making the student understand what you're trading in, that not only is the good itself worthwhile, but what are the rights I have to it? And that bit about what rights I have to it has been slighted a lot in most of the textbooks. There's a fellow named Cliff Holderness who will be coming to this conference we're going to be having later in the week, who has written two good papers on the transferability of a right to, say, that chair. If you and I, quote, own that chair, you and I, we got a problem of deciding whether we're going to sell or not and how we're going to split up any proceeds. We got another problem if he walks along and joins us, sits down, and now does he acquire rights to it by virtue of having come in the room and sat down with us? Is the set of, quote, owners open or closed? And he says, unless the set is closed, the idea of property rights becomes very vague, because you don't know what they are, because everybody in the world can come in and join you. And so, it's like going into a city. The city says, you now own this, you're now an owner of this auditorium in this city. And I said, well, let me tell you a story. We were up at Shasta Dam up in Northern California with Bill Meckling, and the big dam there, and the guide said, and you all own this dam, it's public property. Bill said, I'll sell my share for 10 cents. Well, the guide was very upset about that. But I said, Bill, that's right. What the hell does it mean you own this thing? What do you do? Well, that's the time everything was this ownership stuff. Holderness has this good paper on trying to define what he means by a closed set of owners as distinct from an open set. Where an open set, you can be joined like a symphony orchestra. They say, oh, come on and be part of our orchestra. Now, what a closed set isn't quite clear enough defined yet. I think he means by it, and as I read it, that to come in, you've got to buy your way in. You've got to pay something to the rest of us. And he talks that way. That the distinction of what defines closure is still a little vague. But if you talk about having the idea of private property rights and say that we have private property rights, which we're going to share, no one else can join without our permission. Now, in a corporation, it's a privately owned thing. We have several owners, but a third party can come in without our permission, but he has to buy his way in. Mm-hmm. He's got to buy his rights from one of us. And that, I think, is closure, as he puts it. If you've got that kind of limitation on the class of owners, you've got what could be, or what I'll say is, or what he says is private property rights. Without that closure, you've got something undefined. You've got some other class. And to call both of these as ownership is very misleading and very dangerous. But that is a weak point, I think, in most of the literature I've read in the law journals and elsewhere about what do you mean by property rights. I'm convinced the Supreme Court doesn't understand that.
Most of us would agree that I have some right to lobby regulators. And let's suppose you have a piece of land, and it's a nice-looking piece of land.
Why did you say to lobby
To
me?
lobby.
To talk to me.
Well, but you're not the regulator. You have property rights in a piece of land, let's suppose.
Well,
All right?
I own this hotel.
All right. And someone who's a stranger to both of us happens to be a local politician. And I say it'd be nice if this hotel lowered the prices for me. Or just let me use the parking lot to park my cars in.
Yeah.
All right.
Come and ask me, and I might say yes, and I might say no.
But instead of asking you, or instead of offering you money, I might go to the politician and say,
sure, you would.
all right. Yeah. So in that sense, is there a conflict between your property rights and my political rights?
No,
No?
I don't see any conflict. You have the right to go to talk to anybody you want to talk to persuade them to commit suicide, to persuade them to marry your daughter, persuade them to give you money, persuade them to vote, which is, persuade, influence the king. Nothing to do with property rights. Now, if you tell him you want to persuade him to take away my property rights, you got a right to do that. After all, the property rights are what the rest of society will enforce for me. If the rest of society says we're not going to enforce rights anymore, okay, don't have them, they're gone.